Hello, welcome to another episode of Good to Know Family Law Topics. Today we're going to talk about an issue that deals with student loans. And the issue is whether or not there's reimbursement rights related to the community money being spent to pay down a spouse's student loans. Watch this episode and you'll get the answer. Today we're going to talk about how the court orders the payoff of student loans when there's a divorce. And to illustrate how this is done, we're going to discuss marriage of Mullencow, which was a published appellate court decision in the year 2020. In this case, the mother and father met in India. In 2009, the mother graduated from a medical school and began her residency in the state of Michigan. She lives with her parents while she completes her residency and starts paying off her considerable medical school loan debt while she's with the parents. Meanwhile, the father is living and working in India. On August 27, 2011, the parties get married. Now, at this time, the father remains in India and the mother remains in Michigan living with her parents. That's how this marriage begins. Now, from July 2012 through May of 2013, the mother works for a hospital in Michigan and continues to live with her parents, paying them for their living expenses from her nice $225,000 a year salary. But in May of 2013, she moves to California to begin working for a new healthcare provider. At this time, the father also leaves India, moves to California, where the couple finally begin living together as man and wife. In July 2013, the father gets his residency card, and mother, out of her income, pays for his immigration fees. During the marriage, the mother pays off debt from her salary. She pays off all of her medical school loans to the tune of $130,000 by early 2014. She also pays her parents back for loans they gave her while she was living with them, first in $2,000 a month installments. Then she gave them two very large installments. First, in 2014, she paid them $48,000, and in 2017, she paid them $60,000. It's important to understand that these loans were paid off with her income during the time that she was married and living with her husband, and these funds were community funds. Between September 2011 and July 2013, she spent more than $75,000 for gifts to her family and loan repayment to her brother. She also pays for cruises for her parents and her uncle, a trip to Vegas for her brother's birthday, his airfare for a Christmas visit, and a cruise for her parents and her father.
Vegas? I want a sister like that.
Mom also pays for 2 Hawaii vacations and a trip to India for the father during the time that they're married and living together. Now, during the time that they're married and living together, father has earned no income in California. He did earn income while he was living in India, and he accumulated assets, but he was unemployed and not earning a single penny while living in California with his wife. In 2014, the mother gives birth to the party's child. And unfortunately, in January of 2015, she files for divorce. Marriage wasn't working out. So the parties go to trial. They're unable to settle their issue. And the biggest issue here is going to be whether or not the community is entitled to reimbursement pursuant to Family Code Section 2641 for the community's funds being used to repay mother's student loans, along with reimbursement for other non-educational loans and gifts of community funds to her family members. In trial, the father testifies that the marital standard of living was not commensurate with the mother's salary because they lived so frugally to allow mother to pay off her student loans. Well, unfortunately for the father, the trial court denied his reimbursement request under 2641. In reaching this conclusion, the trial court found that the facts of the case, i.e. the mother works and pays off educational loans while the father does not work and contributes nothing to the payoff, does not establish the kind of situation in which the Family Code Section 2641 reimbursement was intended. In fact, the trial court states that reimbursement under these facts would be contrary to the law and unjust. The trial court made a statement that basically said that the father was really not applying himself during the marriage, and so it would be unfair for him to get reimbursed since he wasn't contributing anything financially to this marriage. Well, the father wasn't very happy with this decision and filed an appeal, and believe it or not, the Court of Appeal reverses and remands. In the published part of this opinion, the Court of Appeal found that the reduction or modification of reimbursement is allowed to the extent that circumstances render the disposition unjust. And then the decision went to describe when it would be unjust in a certain situation where a party was not entitled to reimbursement. The exceptions where it would be unjust include where the community has substantially benefited from the education of one party is offset by the education of the other party to which the community also contributed, and where the party's education reduces his or her need for support. The court also stated that if there's an agreement between the parties, there has to be an express written agreement that talks about this reimbursement. In this case, mother had argued that there was an oral agreement between the parties that she would not have to reimburse the community, but the court looked at the statute and said, hey, if there was an agreement, it had to be in writing. So the Court of Appeal held that Family Code Section 2641 apply where the parties have mutually benefited and neither spouse will receive a windfall. And in this case, the mother got a windfall because she used community funds to pay off a separate property debt. Here, the father did not receive commensurate benefits to the mother because he did not enjoy the standard of living the community could have achieved. He did not need to earn his right to reimbursement, and his failure to work did not preclude his entitlement. In other words, it didn't matter that the father was unemployed, that he hadn't earned a penny while he was married and living with the mother. He didn't need to earn his right to reimbursement. It's a reimbursement to the community, and in this case, mother failed to meet her burden. The court stated, quote, 18 months of modest living expenses, along with 4 trips, did not rebut the presumption that the community had not substantially benefited from the community contributions to the mother's education. And the court held that any strong understanding between the parties regarding reimbursement does not qualify as an express written agreement that would preclude reimbursement. So that was a very important decision because there aren't that many decisions related to reimbursement of student loans. The main takeaway here is that you may possibly get reimbursement if the community has been paying for your spouse's debt during the marriage, student loan debt that I'm talking about. One other thing is as to the division of student loan debt, each spouse is going to keep their own debt when they divorce without an offset. Thank you again for joining us on Good to Know Family Law, and I hope to see you next time.